Afternoon, everyone, and welcome to the Budget and Finance Committee hearing for Monday, September 26th. I'm Paul Krikorian, Chair of the Committee, joined by my colleagues, Mr. Bonin, Ms. Martinez, and Mr. Blumenfield, and we're ready to begin. We're going to begin with public comment on our agenda items, as well as general public comment. So I'm going to call Mr. B, who I assume to be Mr. Spindler, to go ahead and come on up and take your 5 minutes first, followed by Mr. Previn.
Yes, very good. Noting today's corruption watch, you'll note that there was an item. This is very good, City. You were going to give Tharp and Howell, LLP, a waiver of a conflict, but you dropped it off today's agenda at the last minute. So for all you watchdogs out there, that was a very good move, because you know that was the wrong thing to do. So first of all the attorneys here, thank you for suing the city. I greatly appreciate it. Keep up the good work. That's why I'm here, to compliment your work, like starting with number one. Here we have CEQA. Now, see, CEQA is a state law. It applies to every part of the state except one place. Yes, on Thursday night, for example, in the South Valley Planning Commission, it does not apply. Why? Because somebody got in CD2 a building permit with a 26-year-old outdated CEQA oil drilling and tank approval. But you see, the Youth for Environmental Justice sued the city of Los Angeles over just such a thing, got their ass kicked, and now they will comply with proper CEQA guidelines and have an environmental impact report for any project that may be leaking oil or gas. And this applies to the whole city and the state, except for some reason Mr. Cochran's South Valley Planning Commission. He hasn't gotten up to speed yet, but you'll get him, don't worry, look at that. And then again, Shalem First versus City of Los Angeles, bicycle versus auto accident. We love bicycles here. Mr. Bonin loves bicyclists. Everybody loves bicyclists, so double this award, whatever the settlement is, just for today, double the award for this fine person. And then we have an inverse condemnation on number 3. From Bob Blumenfield's district. What happened, Bob? Strong-arming people again? You can't take away land without just compensation, saith Franklin et al. In our Constitution. So, Hoombin versus City of Los Angeles. Just remember, counsel for number 3, condemnation is a taxable event. So that means when you get your award under inverse condemnation, you have to pay federal and state taxes on it. So make sure when you settle with these cocksuckers, you include that in the settlement so the net payout is the just compensation. They'll try to trick you on that. Now you go number 4, Richard Diamond. Oh yes, we've seen this before. Discrimination, retaliation, and harassment. The 3 things people live in this city are discrimination, retaliation, and harassment. This is not the first time they've been here. Please pay these nice people their money. They need to get on, especially when you see a state that means somebody passed on, and that sucks. So please get them their money. Then we get number 5 in CD 11. Well, that's him over there. Slip and trip, fall accident should be a simple case. Why the fuck is it taking 3 years on a slip and fall, please? Why? Let's get this done today. Number 6, the right choice. AT&T, refund of taxes. Yes, AT&T, they did steal your money, you're right, and get your money back. Make sure you get interest, restitution, and an apology. Now you get number 9, which I think was moved to number 8, because number 8 used to be the Tharp and Howell scam. So now we have the LA Building and Safety which should be listed by the UN as a terrorist domestic organization. The LADBS is terrorizing small businesses and landowners in the city. So no to them. And the Office of Finance report, investment report for the month of June. Now, we used to have, our member here used to be Paul Koretz. He knows about that stuff, but he was booted off of here because he asked the magic question. What is our rate of return? It's a negative 2%. We're losing 2% every month. That's why they threw him off, the honest Jew on economics. Finally, everybody continue to sue this miserable, disgusting city, bankrupt this city, and make it go away once and for all. Thank you.
Thank you. Mr. Previn, come on up. You have 3 cards on items, so take 1 minute each on 4, 6, and 8, and then an additional minute on your general public comment, if you'd like.
Thank you, sir. Obviously, cross-collateralizing is permissible. And on item number 6,
except that,
just the
with
solid
regard
time.
to the general public comment. So
Okay, we'll do that separately? Sure. Okay, item number 6, greetings. It's Eric Previn from CD2. Item number 6 caught my attention because here what we have is a closed session where the AT&T Corporation would like to go into the back room to discuss with all of you settling their case. Their case I looked at a little bit and has to do with TUT, if it is, and CUT taxes, which are, without getting into the weeds, telephone user tax and communication user tax. And so the laws changed as they do in 2008, and things got a little confusing. And they claim that in 2012, when they merged, that they either overpaid or there was some overpayment. To me, I looked at the details in a legal case, believe it or not. They sued this great city, which I find, I must say, a little shocking given how nice, quite frankly, the city of Los Angeles and the Budget Finance Committee and various members of council have been to that group. So for them to come after us with a lawsuit requires a degree of chutzpah, if I may. But nonetheless, here they are, and here we are. And what they would like is for us to cut their bill by about, looks like $423,000 is what their lawsuit says. But I think that they want more, and I think that we're willing to do more or less whatever they say until now, because what I think is that these kinds of discussions would benefit from being held out in the open. Because I think, the public has a lot of experience with this group, and we know that they are engaged in some lobbying activity, which is it is their right. Companies do that to influence people. They have hired Englander, Knabe, and Allen, who I guess Mr. Englander is not here today, but that's okay. And neither is Mr. Kretz, by the way. Did he get replaced? But nonetheless, fine. This is lobbying. Lobbying is done above the board and above the transfer, but it's unclear what they're lobbying about all the time. It's very murky from us. There was also Kindle Gagan who have been involved. And to the tune of, I'm not going to scare anybody, I don't think, by saying over $1 million since I started looking. This group has poured into those lobbyists' pockets, who you guys kind of cavorted with. Now, I don't know that the lobbyists are allowed to go in the back to go over the terms here of this, what looks like a fairly minor discrepancy of just a few $100,000 for a company that is paying a lot of tax. So I got to tell you, I would suggest the following, that we say, hey, look, AT&T, we are doing our best, we represent the folks. The people in the public are aware of all this influence, so it's making it very difficult for us to give you a sweetheart deal. So our proposal is drop this immediately, run in the opposite direction, and let's move forward. Because otherwise, I think that the public has the feeling that AT&T, who is no stranger to tricky games, and believe me, if they result in a charge on if you result in a deal with them where you owe them money, they make arrangements to pay it over a period of time, but they do not forgive and they do not reverse. And we're not intimidated by the AT&T lawyers because they need us on multiple levels to be able to operate appropriately. Yes, sir.
This is your general public comment.
Oh, we're going into that now? Fair enough.
Continue if you'd like, but
Well, I think I've made that point, and I would like to move forward. Thank you for bringing to my attention. Item number 8, I just want to say thank you for taking a look at the liens, the proposals, to maybe see if we can improve this system. I think there's been a misunderstanding. We didn't mean go off and see if we could add up $12 registered mails to get these people for sure tagged before they have to come down to council to settle their liens. We meant let's consider an amnesty program, or let's consider some way to streamline and make more effective, not elongate the period during which we're expecting people to pay these onerous and painful liens. That you could reference Marquis Harris Dawson's district, where an elderly couple with a horrible situation in probate being chased around in circles. It is unbearable. So thank you. And once again, take this one and bring it back to the drawing board. We can go in a direction where we are achieving revenue but not torturing residents. So thank you.
Thank you, sir. Mr. Williams, are there any other cards on agenda items?
No, sir, there are
Any
not.
General public comment cards?
No, sir, there are
General
not.
public comment is closed, and public comment is closed on all agenda items. That brings us, members, I would have proposed item 9 as a consent item. If there's any, unless there's an objection, I'd like to have that be noted and filed. Seeing none, that's the action of the committee on item number 9. That brings us into closed session, and I'll look to the city attorneys to see if there's any particular priority. Otherwise, we'll go in numerical order. All right, we are back in open session, and I'd like to call item number 8.
Item number 8 is the Los Angeles Department of Building and Safety report relative to improving the current process for nuisance abatement and code enforcement for non-compliance liens.
Good afternoon.
Good afternoon. Stephen Geller, the Department of Building and Safety. Before you is a report that is as a result of an instruction from Plum on June 21st, asking the Department of Building and Safety to make recommendations to simplify and improve the current process for nuisance abatement and code enforcement compliance liens processing. The report is an overview of the lien recordation process from the time that code violation is determined to exist and an order to comply is issued to the very first time that an invoice is mailed to a customer. In order to put this report together, we worked very closely with staff from CD10, CD11, CD14, the CAO's office, and the city attorney's office. The main recommendation in the report is to transfer the public hearing, the liens public hearing, are currently held in City Council to be delegated to the Board of Building and Safety Commissioners, also called LABBSC. In addition to the recommendations within the report, I'm also happy to report today that the department has implemented a number of enhancements that are already showing improvements to the process. Those enhancements include ensuring that we have an inspector and an accountant during the council hearings discussing the liens process items. We also ensure that all questions that we are not able to answer during the city council hearings, we are able to get back to the customers on time and answer them adequately. We've also created a database which is responsible for reducing the rare cases or incidences of double lien recordation on the same property. We're now sending invoices to both the landlord and the tenant. And finally, the report includes a flow chart that walks you through the code enforcement process from the initial order to comply to the time that we start preparing the lien. Thank you for the opportunity, and I'm available to answer any questions that you may have.
First of all, thank you. We've had many conversations about this exact issue, and I think this is a welcome list of changes to make to this process that will be a big improvement for our customers and take a load off of council, hopefully, and I think it's a great step forward. I guess my initial concern is on the cost of it, and the more so because in a full cost recovery environment, one of my concerns is we already have such a high level of punitive costs structured into the lien process with the late fees, with the non-compliance fees and everything. It just, the increase is so geometrical that I'd actually want to, it's not on our agenda today, but I would actually want to look at how we can make some of that easier for people to comply with, not harder by raising their costs. But that's not before us today. But what is before us today is a further increase of over $1 million in costs that we'll have to capture some way. And I'd be a little concerned that that goes on the backs of the people who are expected to comply with these things. So I love the policy direction. I think we should, we should continue to look at this. I guess what I would suggest, members, is that we have some additional CAO input on potential cost reduction options in pursuing these policies before we ask the city attorney to begin drafting an ordinance. Just because if we come back with an ordinance and the cost analysis at the same time, we're in that position of having to, kind of either thumbs up or thumbs down on something rather than having a dialogue about what might go into that ordinance. So that would be my suggestion. But I welcome your thoughts. Mr. Blumenfield?
Yeah, no, I agree with that. And I'm also really glad that we're finally doing a lot of common sense proposals here. Couple of things though. From the DPS report, of the approximately 7,800 orders to comply that are sent out each year, about 2/3 of them, 5,200, are not corrected within 45 days and get assessed a non-compliance fee. It seems like a really not a great non-compliance rate. Do we know how we compare with other jurisdictions on that rate?
So we've actually done a best practice report. We did it about 4 years ago. And we did it because there was a perception that our process is pretty bad. So we went to, we went to San Diego, we went to San Francisco. We couldn't go to New York, so we spoke with them. And as a matter of fact, they followed up by coming to LA. We also spoke with Chicago. And what we found out is that our process is actually more efficient. We actually get people to comply more than all the other cities that we visited. But in addition to that, of course, our success rate in revenue collection was also much better than all the other cities that we interacted with.
That's interesting. It's a little scary. It doesn't, it's great to know that we're doing better than the rest, but it still seems, from the amateur perspective of looking at that, like it's not a large rate, but obviously it's good to be running faster than the rest of the herd, so to speak. The order to comply notice is sometimes, as I understand, it's kind of legalistic. Has there been attempts to try to create a plain spoken language version of that letter that might be more successful? And the other piece to that is, I guess it's not in Spanish or in other languages, right?
We're actually working very feverishly right now to try and translate most of our forms and our orders to comply. I will say that we've kind of hit a little snag with regard to order to comply, because what it's going to force us to do, which is not a problem if we are going to be able to get staffing for it, is that we will have to have folks who will be able to read the forms once they are written out in Spanish. We've translated them, but we haven't put them out because we don't have the resources to get the requisite number of people to read and translate and to be able to respond in Spanish.
Well, it seems like kind of a no-brainer for us that we need to get, because we have, I'm sure, what percentage of the folks that are currently being ordered to comply are Spanish-speaking only? Do we know that?
We don't know that, but currently what we do is that when we have a customer who is monolingual in Spanish, what we do is we get somebody from staff who understands Spanish and we'll help them out. We'll do the translation. If we are not able to, we go through the city clerk and get the services.
And is there a reason why the order to comply and the invoice for the initial code violation inspection fee are not in the same letter? Like, we seem like we're sending two different letters out. Is that something we could send at the same time?
So when we go out to a site and find that there's violation, we actually leave something there, and we also send something in the mail to the homeowner to let them know that there's a violation. After that, of course, we send an invoice. I'm not sure that
On the first notice that you leave, there's not a, this is the violation, this is the invoice, and how you pay for it. And this is basically how much it costs, as I understand it. Maybe I'm wrong on that.
I will have to double check on that. I thought that we do have information or a telephone number to call to make a payment. But basically, what they're supposed to do is that they need to wait until they get invoiced before they pay. And I think people normally do that. That unless you have an invoice to pay something, you really don't feel like you're under the obligation to pay for it.
Thank you. Mr. Chair, I apologize. Arts and Parks apparently needs me for quorum, so I'm going to run over there. Right now, you have a
You
quorum.
heard our direction. You have
I'm good
you have
with
no
it.
objection? Okay, good.
You have a quorum.
Mr. Bonin. Sorry.
Thank you. Mr. Ungley, thank you for this report. The motion that Mr. Wesson and I did was born of frustration, for sure.
Understand.
I think it's a little bit stronger than a perception that the process is a mess. I mean, in council most days it feels like a hot mess. It really does. I mean, there are folks who come in and they claim that they took care of this a long time ago and we haven't caught it, or they claim they never got the notice. And I mean, there's just so many stories that sort of get kicked back and continued. I mean, it feels like, a third of them maybe, where there's some sort of problem with the process. So I'm glad that we're fixing it. And hopefully there can be a more thorough review of stuff at the Building and Safety Commissioner's hearing, where a lot of this can get more vetted. But I completely concur with Mr. Krikorian's recommendation that the CAO look at some of the financing aspects of it. I'd like to see, I think this is a perfect example of, my God, the government's coming to get you. I mean, that's how this feels. It's sometimes someone may have done something wrong. Sometimes they did it inadvertently. Sometimes they may not know they've done something wrong. And we come and we say we've sent them a notice. They may not have seen the notice. And then all of a sudden we slap a 250% penalty on them. I mean, I think the 250% penalty is pretty egregious. I'd like to see us do something that's a little less extreme than 250%. Maybe there's various steps. But I've also been concerned in some of the cases I've seen where we might be delayed in processing or mailing notices due to our own internal problems, and they're accruing interest on how much they owe us at a time when we haven't even notified them of stuff. And I think that's a problem too, all of which gets to sort of the financing aspects that I hope you guys in CAO can work with before this comes back. But I'm glad to see building and safety acknowledge in this report that there's a problem, because honestly, when we started these discussions with John Gregory and on my staff and Justin Wesson, I don't know that everybody was on that page and acknowledging that. And so I'm glad to see that we've got that now, because it is a problem, and it's a very public problem. And I'm glad we're starting to fix it. I love the recommendations. I think they're good. I agree we need to look at some of the financing aspects of it, and I hope we can make the costs more reasonable and less extreme when they suddenly go to a late fee.
Just to give you context, and I don't disagree, but just to give you context on how some of those fees got to where they are. About 7 years ago, our code enforcement force was reduced by more than 50%. And the reason was that there's no money to be able to do this. But despite that, we were still getting a lot of calls from almost all kinds of districts, but we didn't have the staff to be able to do it. So what we were advised was to come up with ways to get more revenue, and that's how we got there.
I understand that. It's still scarier and more punitive than an experience with a late registration at the DMV, and that's probably not a standard we want to exceed.
I agree.
Ms. Martinez?
I had a couple of questions. So what's the process for designating the board as the hearing officer? Do we have to adopt an ordinance or make a municipal code change? Does anybody-
Yes, so the state government code requires that any Brown Act body that is formed be formed by the legislative body, and it's going to be done through an ordinance. So in this case, we have a recommendation for city attorney to provide a draft ordinance, and it is within that ordinance that we will get authority to be able to do this.
When do you see that coming to us, in the ordinance?
The city attorney's office is not represented here today, but I believe that maybe a couple months, if they understand that there's some sense of urgency required on this.
And my last question was I wanted to make a request. Is there a way we can look into a payment plan option? Can you report back on the feasibility of creating a longer payment option of 12 to 24 months to pay the lien?
Absolutely.
Sometimes when you're, sometimes I see these $9,000, $10,000 liens. Unless you have that kind of cash, I don't know how people come up with this money. I just want to figure out a way. At the end, we want to collect the money, so I would hate for folks to get into further debt. So we can look into that as well.
We'll report back on that, yes.
I'm tempted to ask this almost every council meeting because every council meeting members of the public rail against liens as though we're throwing people out of their homes. And I just want to maybe get from you the sense, has the city ever foreclosed on a lien that's been imposed for one of these fines? Or is it merely a collection vehicle for some future date when the property is sold?
It's a collection vehicle. I don't believe that we've ever kicked somebody out of their home. What happens is that as soon as City Council gives us the authority to record a lien, we send that information to the county assessor, who in turn attaches it to the tax assessment or to the tax rolls. And so the property owners get to pay for this not in one lump sum, but they pay it in different increments until they're done. But we've never actually forced any sale.
Does it go on someone's credit rating?
Say that again?
Does it go on someone's credit rating?
It does.
Well, but the debt would, regardless of whether there was a lien. So if we report the debt, that would be an adverse credit.
Right.
It does, and actually it does even before we get to the lien process, because the mayor's executive directive number 5 requires that when accounts are delinquent, that we send them to collections. Yeah. So the moment we send them to collections, they're already dinged with in their credit.
Right, but my thing is sometimes folks haven't gotten the notice, or the fee has gotten so high that it's sort of locking folks into a cycle of poverty if you then ding their credit rating. And if we're streamlining the process, hopefully that'll happen less.
Yes.
Does it also interfere with whether or not you can renew your homeowner's insurance?
I don't believe so. I don't
Okay.
believe it affects.
Shouldn't. Could conceivably affect a refinance option.
Yeah,
but
I know.
it was-
I'm
but
sure it
it's
would
such a
have
small amount of money relative, it would be unlikely.
Thank you.
Okay, so with that being said, I think, members, what I'm hearing is we should continue this item in this committee, and we should request that the CAO report back to this committee with information about with analysis of the estimated costs in this report, review of fees that would be necessary to support the program, and also options for reducing some of the more draconian punitive fees that are involved already. I'd like the CAO to report on options for reducing the annual cost of the recommendations that are proposed in this report, and then also, to Ms. Martinez's point, to report on with recommendations about
Payment plan.
a payment plan. Right. Yes. And then, so that we'll continue this matter, ask for that CAO report back here, and then we should also receive and file Building and Safety's report of August 19th, because that's been supplanted by the report that's before us now. So,
Let me ask a question.
Yes.
Councilmember.
Yes.
Would it be possible, though, to, while we do this, to instruct the city attorney to start working on our ordinance?
Well, it would be, but my preference would be not to initiate that process until we've had a chance to
Okay.
evaluate, based on the cost and other information, what should be our appropriate course of action. Because once they start drafting something, we're late in the process to make policy changes. And
Okay.
so we'd prefer to have the policy set before we move.
Agreed. Agreed.
Okay?
Yeah.
All right, so is that, everybody in agreement with that? Okay, that will be the action of the committee. And is there any other business before us?
No, sir, that clears the
Thank
desk.
you very much.
All right, then we are adjourned. Thank you.